Jury has been excused. Attorney Smith, I'll hear from you on the record.
Yes, Your Honor. At this point, the defense would make a motion for judgment of acquittal under Practice Book 42-40 and 42-41. It is the state's burden to prove its case beyond a reasonable doubt as to every element of the crimes charged. I'll focus my arguments on the crime of murder that has been charged against my client, but I would direct it to all of the charges generally. These are all specific intent crimes that have been charged by the state, meaning that the state has to prove beyond a reasonable doubt that my client had the specific intent to kill James McGrath. And I would argue that the evidence that's been put forward so far is insufficient to show that specific intent on the part of Mr. Valle. And I would also argue that to some extent the state's charges here bolster that argument, because this fight takes place in a video that we have seen that encompasses all of 18 seconds. And during that time period, my client had the same intent with regard to all of these people that were attacking him. And if it's only assault as to some of those, as far as the intent that was used, then I would argue that, number one, that's the same intent that he had as regards all of these people that were injured that evening. The evidence as far as the specific intent is muddled at best, but certainly does not rise to the level of proof beyond a reasonable doubt. We have heard from witnesses, many of whom were inconsistent within their own testimony, but certainly inconsistent in the aggregate as we look at what they claim to be able to see. Most striking, I believe, is the inconsistency between what they can recall and versus what they are unable to recall. And I understand that that is an argument that goes perhaps towards the weight of that evidence, but I think that it goes so strongly towards the weight of that evidence that it simply cannot be deemed as rising to the level of proof beyond a reasonable doubt that my client had the specific intent necessary to prove the murder charges, nor to prove any of the assault charges that have also been levied against him. And for those reasons, I would move this court to grant a judgment of acquittal pursuant to the practice book sections I've already cited.
Thank you, Attorney Smith. Does the state wish to be heard?
Yes, Your Honor. The state would oppose the motion for judgment of acquittal at this time. We believe that the jury and the evidence could allow a reasonable jury to find that the defendant brought a knife to a home that he had no right to be at, that he started a fight, and during that fight, he had the specific intent to injure the first three individuals that he stabbed, stabbing Ryan Hines 3 times in the chest, side, and lower area, stabbing Faison Teal once in his upper elbow, and stabbing Tommy Connery 4 times in his legs by going after him with the intent to injure him. He then runs back, gets back to the car, and then comes back into the fight. We've heard evidence that people were leaving him alone, no one was going after him. He turns around and specifically goes after Jimmy McGrath and stabs him in the chest. I think that a reasonable jury can infer what his intent was based on the manner in which these wounds are inflicted. They weren't slash marks, these were purposeful stabbings. They can infer his intent based on the number of injuries that were sustained by the 4 individuals who were harmed here. There were 9 stab wounds. They can infer from his conduct by returning to the area with a knife that his intent was to not only, 1, cause serious physical injury to those individuals, but by coming back and stabbing Mr. McGrath where he stabbed Mr. McGrath in the chest, that his intent was to kill Mr. McGrath. So I would oppose the defense's motion at this time. We believe that viewing the evidence in the light most favorable to the state at this point, that we've sustained the right for the evidence to go to the jury and for the jury to decide this case.
At this point in time, the court is going to take the motion and the opposition to the motion under consideration.
Murphy presiding. Good afternoon, Your Honor.
Good afternoon, Judge.
Good afternoon. You may be seated. All right, so the court's prepared to render its decision on the record on the motion for judgment of acquittal in this case. The motion was sought as to all 4 counts with emphasis on murder. So I'm going to start by saying that in ruling on a motion for judgment of acquittal, the trial judge must determine whether a reasonable, rational trier of fact could find the crime proven beyond a reasonable doubt. A determination of whether the evidence could reasonably support a finding of guilty beyond a reasonable doubt does not require a court to ask itself whether it believes that the evidence at trial established guilt beyond a reasonable doubt. Instead, the relevant question is whether, after viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could find the essential elements of a crime beyond a reasonable doubt. I anticipated the defendant's motion, as it is commonly made at the close of the prosecution's case in chief, wherefore I did review and had the opportunity to look at the following: pattern jury instructions, the notes that I've taken. I've reviewed the statutes that apply in this case, and after careful consideration of the evidence presented at trial and the logical and reasonable inferences that can be drawn from the facts presented and that evidence, I find that the jury reasonably could conclude that all elements of the crimes charged in the information, which include murder at count 1, assault in the first degree at count 2, assault in the first degree at count 3, and assault in the second degree at count 4, have been proved. Therefore, that's moving us now to the defendant's presentation of the evidence. So at this time, Attorney Smith, before bringing the jury back in, I'd like to inquire what is Mr. Valle's decision with regards to testifying in this matter.
Yes, thank you, Your Honor. I've spoken with Mr. Valle, and it is his intention to testify here, Your Honor, and I would ask that he be canvassed as to that decision.
All right, so in accordance with current case law, the Morel Vargas matter set forth in the Supreme Court, I am going to go ahead and canvass Mr. Valle regarding his decision, as it is a constitutional decision. Constitutional rights apply here. So at this point in time, I'm going to actually start with counsel. Attorney Smith, have you informed the defendant that he has the right to testify as well as the right not to testify, and should he not testify, the fact finder may not draw any adverse inferences from his choice to not testify?
I have, Your Honor.
Did you also explain to the defendant his right to testify as well as to not testify belongs to him alone, and that no one else can make that decision for him, including counsel?
Yes, I did, Your Honor.
Did you also discuss the advantages and disadvantages of testifying in this particular trial?
Yes, I did, Your Honor.
Mr. Valle, I would ask you to please stand. I am going to ask you some questions. Thank you. So, Mr. Valle, the court's going to make an inquiry regarding your decision to testify in this case. The inquiry is not meant to have any effect on your decision, but rather to document your decision on the record. Do you understand that?
Yes, Your Honor.
So after consulting with Attorney Smith, is it your decision to testify on your own behalf?
Yes, Your Honor.
Do you understand that you have a constitutional right to either testify on your own behalf or to not testify on your own behalf?
Yes.
Do you also understand that you're not obligated to testify?
Yes.
Do you further understand that if you were to choose not to testify, the fact finder would be instructed not to draw any adverse inferences from your choice to not testify?
Yeah.
Do you also understand that your right to testify or to not testify belongs to you alone, and no one, including your counsel, can prevent you from testifying or force you to testify?
Yes, Your Honor.
Do you feel that you've had enough time and opportunity to discuss your decision with counsel, including strategy concerning the right to testify or to not testify in your case?
Yes.
And you also feel that you've had enough time to consider the advantages and disadvantages of testifying?
Yes.
Have you understood the information that counsel has provided to you relative to your decision? Is it your personal decision to testify in this case, thereby waiving your right to not testify?
Yes.
You're making this decision voluntarily, Mr. Valle. No one's forcing you or threatening you concerning the decision that you've made here today?
Yes.
Okay. Have you understood all of my questions?
Yes.
Do you need any more time with counsel before moving forward? Okay. The court's going to find that the defendant has chosen to testify and has effectively waived his right to not testify knowingly, intelligently, and voluntarily. So, Mr. Valle, you may be seated. Attorney Smith, are you in a position at this time to go ahead and present the defense of this matter?
Yes, Your Honor.
So at this time, then, I would ask the clerk to please bring our jury in.
Yes, Your Honor.
I'm not sure if I stated it on the record. The clerk sent me a note, but just in case I didn't, the motion for judgment of acquittal is denied. Thank you.